Please be seated. Mr. Johnson, the state having rested its case in chief, what says the defense?
Your Honor, ladies and gentlemen, the defense is going to rest.
What says the state?
Stay closed.
Defense closed.
All right, members of the jury, that means that you have heard all of the testimony that you will in the guilt innocence phase of the trial. I will now read to you the charge of the court, after which you will hear argument of counsel, and then you will retire to deliberate. Members of the jury, charge of the court. Kristopher Love, the defendant, stands charged by indictment with the offense of capital murder alleged to have been committed on or about September the 2nd, 2015, in Dallas County, Texas. To this charge, the defendant has pleaded not guilty. You are instructed that the law applicable to this case is as follows. A person commits a murder if he intentionally or knowingly causes the death of an individual. A person commits capital murder if he intentionally commits murder in the course of committing or attempting to commit robbery. A person commits robbery if in the course of committing theft, as that term is herein defined, and with the intent to obtain and maintain control over the property of another, the person intentionally, knowingly, or recklessly causes bodily injury to another. A person commits theft if he unlawfully appropriates property with the intent to deprive the owner of the property. Actor means a person whose criminal responsibility is an issue in a criminal action. Another means a person other than the actor. Appropriation or appropriate means to acquire or otherwise exercise control over property other than real property. Appropriation of property is unlawful if it is without the owner's effective consent. Attempt to commit an offense occurs if, with specific intent to commit an offense, a person does an act amounting to more than mere preparation that tends but fails to effect the commission of the offense intended. Bodily injury means physical pain, illness, or any impairment of physical condition. Deadly weapon means a firearm. Deprive means to withhold property from the owner permanently or for so extended a period of time that a major portion or value of the enjoyment of the property is lost to the owner. Effective consent means assent in fact, whether express or apparent, and includes consent by a person legally authorized to act for the owner. Consent is not effective if it is induced by force, threat, or fraud. In the course of committing theft means conduct that occurs in an attempt to commit, during the commission, or an immediate flight after the attempt or commission of theft. Individual means a human being who is alive. Owner means a person who has title to property, possession of the property, whether lawful or not, or a greater right to the possession of the property than the person charged. Person means an individual. Property means tangible or intangible personal property, including anything severed from land or a document, including money, that represents or embodies anything of value. The following definition applies to the offense of capital murder. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. The following definitions apply to the offense of robbery. A person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to circumstances surrounding his conduct or to the result of his conduct when he is aware of but consciously disregards a substantial or unjustifiable risk that the circumstances exist or that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all of the circumstances as viewed from the actor's standpoint. A person who has been charged with the same offense as the defendant is an accomplice. A conviction cannot be had upon the testimony of an accomplice unless the jury first believes that the accomplice's testimony is true and that it shows that the defendant is guilty of the offense charged against him, And even then, you cannot convict unless the accomplice's testimony is corroborated by other evidence tending to connect the defendant with the offense charged, and the corroboration is not sufficient if it merely shows the commission of an offense, but it must tend to connect the defendant with its commission. You are charged that Crystal Cortez was an accomplice if any offense was committed, and you are instructed that you cannot find the defendant guilty upon the testimony of Crystal Cortez unless you first believe her testimony is true and that it shows the defendant is guilty of the offenses charged in the indictment. Even then, you cannot convict the defendant unless you further believe that there is other evidence in the case outside the testimony of Crystal Cortez tending to connect the defendant with the commission of the offense charged in the indictment, and then from the evidence you must believe beyond a reasonable doubt that the defendant is guilty. Now, bearing in mind the foregoing instructions, if you unanimously agree from the evidence beyond a reasonable doubt that on or about September the 2nd, 2015, in Dallas County, Texas, the defendant intentionally caused the death of Kendra Hatcher, an individual, by shooting her with a firearm, a deadly weapon, while in the course of committing or attempting to commit the offense of robbery, then you will find the defendant guilty of capital murder. If you do not believe that the defendant is guilty of capital murder, or if you have a reasonable doubt thereof, you will consider whether the defendant is guilty of the lesser included offense of robbery. Now, bearing in mind the foregoing instructions, if you unanimously believe from the evidence beyond a reasonable doubt that on or about September the 2nd, 2015, in Dallas County, Texas, the defendant, while in the course of committing theft of property and with the intent to obtain or maintain control of that property of Kendra Hatcher, without the effective consent of Kendra Hatcher, and with the intent to deprive Kendra Hatcher of said property, did intentionally, knowingly, or recklessly cause bodily injury to Kendra Hatcher, then you will find the defendant guilty of robbery. If you should find from the evidence beyond a reasonable doubt that the defendant is guilty of a charged offense or a lesser included offense, but you have a reasonable doubt as to which offense he is guilty, then you should resolve that doubt in the defendant's favor and find the defendant guilty of the lesser offense of robbery. If you believe that the defendant is not guilty of any offense, but have a reasonable doubt thereof, you will acquit the defendant and say by your verdict, not guilty. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that the defendant has been arrested, confined, indicted, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or to produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless you are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all of the evidence in this case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. The burden rests upon the state throughout the trial and never shifts to the defendant. If the state fails to meet its burden, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning this guilt. At times throughout the trial, the court has been called upon to pass on the question of whether or not certain offered evidence might be properly admitted. Do not be concerned with reasons for such rulings and draw no inferences from them. Whether offered evidence is admissible is purely a question of law. In admitting evidence to which an objection is made, the court does not determine what weight should be given such evidence, nor does it pass on the credibility of the witness. As to any offered evidence that has been rejected by the court, you of course must not consider the same. As to any question to which an objection was sustained, you must not conjecture as to what the answer might have been or as to the reason for the objection. You are instructed that the defendant may testify in his own behalf if he elects to do so. But if he elects not to do so, that fact cannot be taken against him. The defendant has elected not to testify in this phase of the trial, and you are instructed that you cannot and must not refer to or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. You are instructed that if there is any testimony before you in this case regarding the defendant's having committed an offense other than the offense alleged against him in the indictment in this case, you cannot consider said testimony for any purpose unless you first find and believe beyond a reasonable doubt that the defendant committed such offense, if any was committed, and even then you may only consider the same in determining the motive, opportunity, intent, preparation, plan, knowledge, or state of mind of the defendant, if any, and for no other purpose. It is only from the witness stand that the jury is permitted to receive evidence regarding the case, and no juror is permitted to communicate to any other juror anything he may have heard regarding the case from any source other than the witness stand. In deliberating this case, you are not to refer to or discuss any matter or issue not in evidence before you, and you are not to talk about this case to anyone not of your jury. Mere sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling is to play no part in your deliberations. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and the weight to be given in testimony, but you are bound to receive the law from the court and be governed thereby. After you have retired to consider your verdict, no one has any authority to communicate with you except the bailiff who has you in charge. You may communicate with this court in writing, signed by your foreperson, through the bailiff who has you in charge. Do not attempt to talk to the attorneys, the officer, or the court concerning any questions you may have. After argument of counsel, you will retire and select one of your members as your presiding juror. It is the duty of the presiding juror to preside at your deliberations, to vote with you in arriving at your verdict. Your verdict must be unanimous, and after you have arrived at your verdict, you may use one of the forms attached hereto by having your foreperson sign the particular form that conforms to your verdict. Signed by me, Tracy Holmes, Judge of the 363rd. The following pages of verdict forms. And they read as follows. We, the jury, unanimously find the defendant guilty of capital murder as charged in the indictment. Or, we, the jury, unanimously find the defendant guilty of robbery as included in the indictment. Or, we, the jury, find the defendant not guilty. And there is a signature line for the presiding juror to sign and print his or her name. The charge will go back to the jury room with you, so do not be concerned about not catching everything that I read. There's a lot of legalese in here. And if you do send a note to the court, please sign and print the name of the presiding juror.